Hello, and welcome to another edition of the LeaseDefend Podcast. I am your host, Art Veal, and I hope that I can help you with some information today. Today, I am going to be talking about some addendums and some extra pieces that you can add to your lease when you're putting a lease together for a tenant. Now, to be fair, I run a rent-to-own company, so I am typically renting to people that are renting houses. I don't do a lot of apartments, and I'm also renting to people that are responsible for their own repairs and improvements on the property. So while all of these addendums or all of these add-ons to your lease, I use all of these, but they might not work for you depending on your situation. You have to adjust and use what's relevant to your situation. Having said that, every addendum and everything that I'm going to talk about in this podcast is the result of an issue that I've had at some point with one of my properties or with the tenant. And the way it kind of worked was after I had an issue, then I would say, okay, to stop this from happening again, let me put this in writing, and so on and so forth. And so this is the accumulation of about 10 years worth of trial and error with tenants and just different things that come up when renting a property. But I will say this, my lease is a strong lease. In fact, in the Chicagoland area, when I originally started out, I used to do a lot of Section 8 or supplemental income housing. And when I did Section 8, I went to a lot of the workshops to learn about Section 8 and about different things. They used to host workshops and everything. And I ended up talking to the administrators of Section 8 in Chicago and showed them my lease after talking with them, and I was, signing up a Section 8 tenant. And my lease was so strong that the Section 8 administrators asked if they could have a copy of my lease with all the addendums. They wanted to use it as an example in their property management and landlord training classes. So my lease has been kind of strong, and it has gotten me out of countless situations where if I didn't have something in writing, then I would have been on the hook for either a bill, or I would have been on the hook for not being able to do an eviction on a tenant. When I used to do evictions, it would have just made things more difficult. So having said that, an addendum or the add-ons that you put into your lease can make your world much easier if you put the right addendums in place. So like I said, I'm going to discuss the ones that I put in place. So the first thing is the actual lease that you use. Now, I did not make my lease. I actually use, and I use what's called a George E. Cole legal form lease. It's a residential lease, and it was prepared by a attorney's office, and they, made this lease, and it basically is a pretty tight-knit lease that adheres to most of the basic rules that are required with the city of Chicago and our county here. Now, having said that, this lease is available to use nationwide, and it should in most states, work for a bottom baseline lease. It does say on the lease to consult a lawyer before using it, and I would also suggest you consult a lawyer if you're not sure about your lease, because a $125 lawyer consultant, you can do it once. They can give you their feedback on the lease, and then you can make the changes, and then that lease can work for you for the next 10 or 15 years. So that's the basic lease that I use. Now, one of the things I do on my lease is on every page, because my lease is several pages long, I've added an initial section at the bottom right of the lease. I make it so that my company, the leaseor, has to initial every page, and my tenant, the leasee, has to initial every page. The reason I did that was because in court, it can sometimes come up where a tenant can try to claim, if you're doing an eviction or something, they can try to claim that that particular page or that part of the lease wasn't in the lease. So they can try to say, well, he put that in there and this, that, and the other. That wasn't in there when I signed my lease. And by having their initial on every page, it nullifies them making any excuse of saying that something wasn't included in the lease because their initials are on that page. So that's the first thing that I've added to my lease. The second piece that I've added to my lease is at the bottom of my lease, at the end of my lease, I should say, I put an extra line. The first thing is that in Illinois, let me be clear, in Illinois and Cook County, we have some of the toughest laws as far as evicting a tenant. If you make one wrong mistake in Illinois or in Cook County, or specifically in Chicago, not only can they kick out your eviction and you have to start all the way over again, but it can take months to get a tenant out. And not only can it take months, but in Illinois, I'm not sure about the rest of the country, but here there are lawyers that literally come into eviction court and offer free assistance to help tenants basically hold off eviction. So they walk into the courtroom and they say, hey, if there are any tenants here that aren't represented by a lawyer, we'll represent you, and we can't stop the eviction, but we can usually buy you time and get you to, get you there. When I was a fresh new landlord, my first eviction, which I was completely nervous about, I did myself because I wanted to test the waters and see how difficult it was. And it took me, I believe, 5 months to get them kicked out of the property. And it was almost to the point where the tenant almost tried to assault me and tried to fight me in court. He wanted to punch me, and he was about to, but the sheriff was right there. So, you want to, it's something you got to watch out for. So our laws are very strict. So the agreements I'm giving you work here, but if they work here, there's a good chance they'll work where you're at because it's probably not as strict as Illinois and Chicago. So at the bottom of my lease, I have a line that says leasee agrees that by signing this lease, leasee agrees to waive right to jury trial. One of the first distractions that a lawyer tells a tenant when they're filing eviction is to ask for a jury trial, because when they go to court that first time, they'll if they have an attorney, or if the attorney knows anything, or even if the tenant is a professional tenant. Professional tenants are people that know how to abuse the system so that they can stay places rent-free for as long as possible. Then they'll ask for a jury trial. And by on the lease putting in that they're waiving the jury trial, it may not always work, but it can at least bring to the judge's attention that, hey, this person has already waived their right to a jury trial when they sign this lease, and that might speed up the process. So I would definitely add that line. So that's the two lines the two things that I do on my formal lease. Then the next add-on, or a piece that I add on to my lease, is you need to check and make sure there's no lead-based paint disclosure forms required where you're at. Here in Illinois, we have to put a lead-based paint disclosure that just says we're giving them knowledge that we either don't know that there's lead-based paint in the house, or we've done something to remedy it. So you need to make sure that that's not required where you're at. It varies by place. Next, I have a list of tenant rules that we put into the lease. And there are things like the late fee. Here, it's very strict about how you charge a late fee. So I specifically spell out the rules on when we charge a late fee. Your rent is due on the first of the month. After the third of the month, if the rent is not paid, there's a late fee of $59. And after the third, you'll get a notice to vacate and blah, blah, blah. I have about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 rules on this page. Things like by signing this lease, you agree again to waive the jury trial. Money that is paid is first paid to penalties and fees before being applied to rent. The reason I do this is because, let's say your rent is $1,000 a month, and after the third, you get a $59 late fee. If you pay on the 4th, then you pay $1,000. Then I'm first going to pay my late fee, which is the $59, and then you're going to be $59 short on the rent. The reason I do that is because I cannot file an eviction on a late fee. But if the money goes to the late fee first and you're $59 short on the rent, I can file an eviction on the $59 you're short on the rent. So I want to make that clear. So that's something that is spelled out in the rules. Another rule is we don't take personal checks or cash to pay rent. We only accept money orders, certified checks, or our escrow company, and we try to push everybody into our escrow company. If you're not aware of that, how that escrow company works, you can listen to one of the other podcasts where I talk about using an escrow company. It's one of the best decisions I've made about my business. Another rule is no painting or electrical work or home improvements allowed without written consent from the landlord. We used to have a problem where tenants would go in and do improvements on the house, and then they wouldn't know what they were doing. In fact, I had one tenant that took an extension cord. They wanted to put a light in their. They had like a back patio, closed off deck on their house, and they wanted to put a light back there. So they cut an extension cord, cut off the wires, and then inside the wall, they ran the extension cord from the light switch over to a hole in the ceiling, and then put a light bulb on the extension cord at the end. Very dangerous, could have burned up the house, but they didn't know what they were doing. So now any repairs, electrical work, or anything like that needs a licensed contractor, you have to get permission from us in written permission. Another one, any repairs above normal wear and tear are due to tenant negligence will be charged to the tenant. That's very important so that they know what they're going to be charged for. We have the right to enter the unit in case of emergency. There are some rules in some places where you have to give 24-hour notice to enter a unit, but if there's an emergency, let's say I had a property where we got a call from the police and water was coming through the front door of the house. So obviously there was some kind of busted pipe and flooding, and the family was out of town. I wasn't going to call them and say, hey, I'm going to wait 24 hours before I go in. We were going in immediately to shut off the water. But I have to give them notice so that they can't say in court or something like that, hey, he illegally entered our unit or something like that. So it's in my rules. Also, we make it the responsibility of the tenant to place and put in batteries for smoke and carbon monoxide detectors. In our state and in our county, smoke and carbon monoxide detectors are required, and they're a good safety issue. You don't want a family to die in your property unnecessarily. So we say that the tenant is responsible for that, and they agree to hold our company harmless in the event that there's a lack of smoke or carbon monoxide detectors. So that's very important. Another thing we do is that we want specific tenants listed on an addendum of who lives in the property. That way, that's for two reasons. One, I want to get an idea of how many people are going to be living in the house, and if there are more people living in the house, I can use this addendum against them in court to evict them for overcrowding the house. Also, it works because if the tenant, let's say we've had this happen before where we get a call from the police and they say that somebody's trying to climb in the window of the house, and it turns out that it's a relative that just didn't have their key, or a kid that's a teenager that didn't have their key or left their key at home, and they want to climb in the house, but the police saw them and they want to verify that this person lives here. Well, that person might have moved into my rental 2 years ago, and I might not remember who lives there. But if I look at this addendum for the number of people and the names of the people living in the house, I can verify the name and say, yes, he does live here, or no, he or she doesn't live there. And so it makes it easier. Again, everything I'm telling you is from experience and things that have actually happened. And finally, I have an addendum on here that says that they should get tenant renter's insurance, because if there's a fire or something like that, our insurance only covers the property. It does not cover their personal belongings. So that's my list of rules. The next disclosure I have on here is I actually have a separate page called a permanent attachment disclosure, which says that if they put something in, let's say they put in new kitchen cabinets, then that becomes a permanent attachment to the house. Now, as I said, I do rent to own, so my tenants often do improve the property. But what has happened to me in the past is a tenant will move in, fix up the house, put in new kitchen cabinets, throw out the old kitchen cabinets, and then because of a lost job or because of a change, or they need to move and they'd never buy the house, and then they turn around and snatch the cabinets out and say, these are my cabinets. Well, this addendum says that you cannot do that. You can't take items that you permanently attach to the house from the house. So that's a very important disclosure. The next one is an as-is repair disclosure. Because I do rent to own, my properties are in as-is condition. Now, that doesn't mean they're in bad shape, but that means that if something happens, which sometimes things can happen after they move into the house, they're responsible for it. We haven't made them any promises that we're going to fix anything. And that comes down to court. If they're trying to go to court to get money or something like that, they can't say, well, he promised me he was going to fix this or anything like that. So it kind of keeps us safe. The next is a rental payment disclosure, where we literally spell out exactly what happens when they miss a payment, if they miss a first payment, a second payment, a third payment, or if because we use an escrow company, their payments are ACH'd out of their account. If they bounce an ACH, we explain what will happen, what will be their fees, what will be their consequences, and we have them sign it. That way they can't say that anything goes against usury laws, which are the laws for how much late fee and fine you can charge someone, because everything is spelled out to them. The next disclosure is an appliance disclosure that just says if you replace any of the appliances in the property, then you have to leave. They become the appliances of that property. Some people will replace a washer and dryer that was in the property because maybe it was old. And then when they move or they don't buy the house and they move out, they'll say, well, I'm taking my washer and dryer with me. They either have to keep my old washer and dryer and put it back into the place where it was at, or they have to leave their washer and dryer, but they cannot just replace it and then take the new one because it's leaving me without a washer and dryer, and I had one when I put them in the house. The final payment, the final disclosure I have is a payment servicing fee, and I use that to tell them that they're going to be responsible for the fee that my escrow company charges every month for managing the account. And I tell them that that's their responsibility, and it's just a disclosure that explains that they're going to be responsible for that fee, and basically abstains me from having to pay that fee. Now, these are the disclosures I put into my lease. I also have another disclosure, and it's a foreclosure modification disclosure, just saying that if because of the way we buy properties, we sometimes take over mortgages, and sometimes those properties are in foreclosure when we take them over and we get the loan modified. But I tell them that if they get a knock on the door from the sheriff or anything like that, which can happen from time to time because the property was in a foreclosure, or maybe they'll get a letter or something like that. It just says that we're letting them know up front that this property is either we worked on a modification and we completed the modification, but that does not give them the right to not pay rent. They're still going to be responsible. And it's not so much to force them to pay rent, but it's really to make them aware that if something like that happens, hey, we're on top of it. We know what's going on, and we're working to fix it. And they're usually okay with that. I've never had anyone complain any way different. And that way it goes up that it's disclosed and they've signed off on it. So if we ever go to court, they can't say, well, I didn't know that the house was under a modification or something like that. So these rules, like I said, have helped me save money countless times over the years and avoid litigation, avoid headaches and arguments with tenants, and they work really well. If you have some other addendums that you've used on your property and you'd like to share, I'd love to hear them in the comments section below. If you'd like a copy of some of the addendums that I've included or I've talked about in this podcast, then shoot me a message in the comments section with your comments, with your contact information, and I'd be happy to share any specific disclosures or anything that we use, and you can add them to your portfolio. So again, hope this helps someone. Hope someone takes some of these and is able to make something of it and save some money and avoid some litigation. As for now, that's this podcast. It's gone a little bit longer than usual, but I hope you've learned something and got some value. My name, again, is Art Veal, and this has been the LeaseDefend Podcast, and I look forward to talking with you next time. Have a great day. Goodbye.